Floor is District Court of Appeal, First District, now in session. All those with cause to plead, go on now, give attention, and you shall be heard. May God save the United States, the great state of Florida, and this honor.
Please be seated. Well, it's nice to see some familiar faces here this morning, even though it's a relatively empty courtroom. We have only one case on the calendar remaining this morning, and that's Thompson versus CVS stores. We've allotted 15 minutes to decide, and Ms. LaQuesto will be happy to hear from you whenever you're ready.
May it please the Court, I am Wendy LaQuesto of Fox & LaQuesto. I'm here today representing Cynthia Thompson, the claimant in this workers' compensation appeal. I'd like to reserve 4 minutes for rebuttal. This case raises 4 issues. The fourth issue is a derivative ruling based upon the entry of the summary final order. And unless the Court has some specific questions about that issue, I'm just going to rest on the arguments made in the briefs. The other 3 issues are really all a means to get to the same result, which is reversal. The first issue seeks reversal of the summary final order because the JCC failed to exercise jurisdiction to determine whether the 2006 settlement agreement was valid, and that agreement is the basis for the summary final order motion. Issues 2 and 3 seek reversal of the summary final order based on the existence of genuine issues of material fact. Under the first issue, claimant maintains that the JCC erred as a matter of law in determining that she had no jurisdiction to determine the validity of the 2006 settlement agreement.
Ms. LaQuesto, let me just ask a question real quick about the summary final order aspect of this. I mean, what was confusing to me is it seemed like the JCC took evidence at the hearing that then resulted in her order. And I understand reading her order, she focuses on a specific component. But if we were to agree with you and reverse the case, would it simply be for the JCC to conduct an evaluation of the record that had been created at that hearing, or would it be for a all-new hearing?
Well, I think on the first issue, because she just aborted any analysis on the validity of the settlement agreement, then that would have to go back for her to make findings on that. I think that it could be left to her discretion about whether she would need additional evidence to be able to decide that fact. I think that's what the evidence was presented about, was whether it was a valid settlement. And I think that there is evidence to decide that. But
I'm sorry, go ahead.
But then the other 2 issues on the summary final order, those are issues of material fact that would preclude entry of that order. And so the remedy for that would be to remand, to reinstate the petition for benefits for PTD and to go forward with the merits hearing, which was scheduled when all this erupted. It was, the first motion to dismiss was filed like the day before the hearing was scheduled. So it's all ripe and ready to go on PTD. Does that answer?
With regard to your first issue, if I understand your argument correctly, it boils down to the fact that even though your client had a lawyer when this settlement agreement was reached and executed, the lawyer wasn't a workers' comp lawyer, therefore the agreement's invalid.
Well, that's one of the arguments. That is one of the arguments.
What's your best argument? Is that your best argument?
I think the best argument is that when you look at the attorney's fees that were given to the attorney in that settlement agreement, $22,000, nearly half of all the settlement, and then you look at what the statutory fee would be under 34-1, which would be about $3,000.
But that would be if all you're settling is the workers' comp claims. If you're settling her other claims against CVS, that might explain that, mightn't it?
It might. I guess we really don't know that. And in fact, we don't even know how much of that is cost and how much of that is fees. But the JCC was required under 440-2011C to approve the attorney's fees if there was a settlement in workers' compensation and any fees, and that's not been done.
But was that claim even preserved at the JCC level? We didn't see anywhere in the record where you made the specific argument that the agreement was invalid because the fee portion was not approved by JCC.
I addressed that in my reply brief, and I cited places in the record in the reply brief where there was argument made by Ms. Thompson's counsel that the procedures that the attorney's fees were exceeded, which could have been awarded under the statute, that the settlement wasn't binding because all the procedures weren't followed to approve it. I admit that the argument below is not as clear and concise as the argument that I'm making here today or made in my briefs, but I don't think that that's Judge Padovano says you have to have the substance of the issue, and I think the substance of the issue was raised below.
Well, what wasn't the focus of the argument below was the agreement's invalid because the claimant was unrepresented, and therefore, with 11B rather than 11C type thing, whereas here the argument is the agreement's invalid because the fees weren't approved. I mean, that's the distinction I saw. Well, and it seemed to be clearly argued below as to that 11B component, if I'm using the right words.
Well, and that's what the employer carrier is arguing now, that there was only one basis, but I continue to maintain that when you look at the record, that not only is he saying it was invalid because she wasn't represented by a workers' compensation attorney, he's also saying that it was not binding. That's the word he uses instead of valid. But it's not a binding settlement, not a valid settlement. That's a set-aside argument. I think that that's a close enough argument, and he says it's not binding because the attorney's fees were never approved. The procedures for approving a workers' compensation settlement were never followed.
Well, what happens if we were to agree with you, or if the JCC ultimately agrees with you and finds that agreement is not binding? I mean, does she have to refund the $45,000 that she received under that agreement?
Well, I don't think that, I think that that's inquiring minds want to know the question to that, but there's a severability clause in this agreement, and if some part of it is found to be invalid, the rest of it stands. So if the JCC were to find that this was invalid as to workers' compensation, that doesn't mean that it would necessarily be invalid as to the harassment claim that was settled and what was brought and settled in circuit court. There is a severability clause in there.
But the settlement agreement doesn't segregate the funds in that way. And further, assuming proper preservation of your argument, if the claimant's attorney in that case never sought a fee for representing the claimant on the workers' compensation claim, would the attorney nonetheless still be required to submit approval for attorney's fees to a judge of compensation claim?
I think you're getting into dangerous territory when you're allowing a settlement agreement like this to settle workers' compensation claims, just without anybody even telling a JCC, okay, I'm not claiming any attorney's fees in this for settling this workers' compensation claim in this agreement. I mean, we have 440-2011. It's got a long history of JCC's oversight of settlements to protect claimants.
But the oversight is not over the settlement in this context. The oversight is to determine whether the fee is proper within the context of a workers' compensation proceeding. And I think that's why the statute makes a distinction between unrepresented claimants and represented claimants. So if the purpose is simply to make sure, okay, if you have competent representation, and the JCC's only job is to make sure that the fee is appropriate. And where here there is no representation that the claimant's attorney was seeking a fee for workers' compensation claims, or in the context where you have pro bono representation? Is an attorney still required to submit fee approval to a JCC?
Fee approval is mandatory under subsection C, and I think when I read the Sanders opinion, I think that lays out the history of what settlements. I mean, there's a provision in the workers' compensation statutes that said claimants can't settle. And this 11C is an exception to that allows it, and 11B. And the whole history of it is that there's always been oversight. They have put in one exception when a claim, they created an exception in 2001 under subsection C to only approve attorney's fees when a claimant is represented. But you can still submit it all to a JCC and have it approved, and that's kind of consistent with the history of it. So, yeah, so I really do think that even if there's zero fees, the idea is that the JCC has to be told there's zero fees.
Counsel, let me ask you about your ambiguity argument. I guess I'm having trouble understanding.
I'm like thinking,
Maybe not like the question. I guess I'm having trouble understanding how the language of the agreement, which seemed to be waiving everything from the beginning of time on, except workers' compensation medical benefits, and I think there was also an it specifically included a waiver of workers' compensation retaliatory benefits. How all that language is ambiguous in any way?
Well, there's no express release of workers' compensation indemnity benefits. There's only an express exception of the release for medical benefits. There's no express exception or release for indemnity.
Why would there have to be? The agreement purports to release all claims except for pending workers' compensation medical benefit claims. Wasn't she already receiving indemnity benefits at that time?
Voluntarily being paid at the time that she entered into it.
But she was receiving them.
Wasn't a claim on it.
So the parties knew she was receiving them, and yet only medical benefits were accepted.
Because at the time that they entered into the agreement, there was
Does that constitute a latent ambiguity under contract law?
I think that when you look at the circumstances of the case, at the time that she entered into the
But we can't consider extrinsic evidence unless we first determine there's a latent ambiguity.
I think the language that I have cited in there in terms of lost wages, that's not compensation, that's not indemnity benefits. There's nothing in the release that even talks about workers' compensation, nothing about 440-2011C.
But it's not required to do that under this court's precedent. I mean, certainly a general release, there's no specific reason to cite the statute. Why isn't a general release effective even when it expressly excludes one type of benefit?
I think, as once I said, I think you're really getting into a slippery slope of now you're going to allow workers' compensation settlements to be made outside the workers' compensation arena by general releases and other matters.
But that's your first argument. It's not your latent ambiguity argument.
Well, I was responding to her question is like, why don't I need to do it? I think the language of the statute doesn't include workers' compensation. I think the course of conduct by the parties in that the employer
You can't
carried
consider that unless you first find there's a latent ambiguity.
Well, I don't think lost wages is indemnity.
Lost wages could apply to her claim, her civil claim, couldn't it?
It could apply to her civil claims, but it's not used in compensation, and neither is pain and suffering.
And it seems to be that you're singling out one type of damage. And if you look at the general release, and it talks about severance pay, salary, accruals, payment of earnings. I mean, there is a whole laundry list of types of claims and compensatory benefits the claimant was entitled to that she expressly released.
And in that laundry list, why is not indemnity or compensation listed? If they have all this whole laundry list of things, why aren't the things that were purportedly settled mentioned in there?
Because it's a general release.
It's a general release except for everything that she's mentioned.
Well, no, it's a general release except for her claim for medical benefits.
The claim for medical benefits that is listed in there at the time that it was made was because they were contemplating another surgery. She was voluntarily being paid.
But how do we know that from the contract?
The contract doesn't speak in terms of, and that's where my ambiguity comes from, it doesn't speak in terms of compensation benefits. It speaks in terms of civil damages.
But, Ms. LaQuesto, as I understand the concept of a latent ambiguity, it's something that occurs because neither side, when the contract was drafted, contemplated the possibility of that event occurring. Your client was already receiving indemnity benefits at this point, so she knew she was receiving indemnity benefits. The employer knew she was receiving indemnity benefits because they were paying them, and yet they didn't accept that claim from the general release.
Temporary indemnity benefits, as I pointed out, that she wasn't, they even defended against her PTD claim and the fact that she was not at MMI at the time she filed it. So she had no claim, no right, nothing to permanent total disability benefits in 2006, and that's exactly what this claim is for. And the agreement says that it's a release as to all claims that accrue up to the date of the settlement, which is 2006. And she had no right to permanent total disability benefits at that time because she was not PTD. So it is at least ambiguous as to that.
Okay, you've got about 30 seconds left.
And and because I have so limited time, and I do want to save a little rebuttal, I will just say.
We're going to give you a minute. Okay,
but I will just,
to their time.
I will just say as to issue 3 that because it was left out of the pretrial stipulation and that clearly says it's a waiver, that the JCC erred in entering final summary order because that the settlement defense was waived.
You've got a little over a minute for rebuttal.
May it please the Court. James Wyman of Henshaw and Culberson on behalf of the appellees.
And Mr. Wyman, you may have 16 minutes for your argument should you find it necessary.
Thank you, Your Honor. Your Honors, if I may address the issue of preservation of error or the lack of preservation of error. In her reply brief, the appellant references having remarked that, in general, that procedural rules were not followed below. And that kind of general glancing reference is not specific enough to preserve the point for review. You have to, with all due respect to Judge Padovano, you have to specifically make the point, and there was no point made specifically in reference to attorneys, the lack of approval of attorneys fees below. And in fact, Claimant's counsel's relentless focus was on the effective lack of representation below. So that, Your Honors, I would submit that issue is clearly not preserved for review. As far as, well, let me take a broad overview here. Under Brewer and
Counsel, before you take a broad overview, let me ask maybe a broad question. I guess what troubles me most about the JCC's order is the requirement for the claimant to repay the temporary benefits that your client was paying at the time the settlement was entered and, as I understand it, continued well after this agreement was entered. And so, even if that does not, we cannot look to that to create a latent ambiguity, there just seems to be an incredible inequity here about the continued payment of this, and then all of a sudden, when you knew you had a settlement agreement, and if you believed at the time the settlement agreement was, you get no more money from us, period, end of story, except potentially medical benefits. So help me get over that equitable concern I have here.
Well, and I would agree with you. It was an equitable decision made by the JCC, and
inequitable? Or
no, well, the basis I would agree to a large extent is equitable, and because it was a decision made not in true equity, but an equity-based decision. The court's got to look at that under an abuse of discretion standard. The trial court abuses discretion in making that determination, and under that standard, I would say no. I mean, the claimant knew that she had released indemnity benefits, and yet continued to accept them.
But on the same token, your argument today is your client knew that you were no longer going to pay any more money to this claimant. I mean, let's get it out of indemnity and anything else, but yet continue to pay it. So.
Correct. And without getting deeply into the inseparability under the law of an employer and a carrier, I mean, there was, and I believe that the JCC took this into account, a malfunction of sorts in communication between the employer and the carrier, even though legally that's not a basis for any kind of determination on those lines. As a matter of equity, determining the way it actually went down, the employer was not talking to the carrier on that point.
And so your argument to us is, on that aspect of the claim, it is nevertheless, because it was our screw-up, or your screw-up, it's nevertheless equitable to require this claimant to pay the money back.
Well, I don't necessarily, to the extent it was a screw-up, but again, looking at the equities, I mean, she continued to, even though she had received a settlement and released her claims for indemnity, she continued to accept indemnity benefits. So, I mean, you have to, balancing those equities, the JCC determined, and indeed the EC asked for below that we'd like that money back because she accepted them essentially under false pretenses. She was not entitled to it. She released those. She says she accepted them under the pretenses that was her understanding of the settlement agreement. Well, that's in contradiction of that contradicts the release, which clearly accepts. I won't say clearly. I mean implicitly accepts indemnity benefits because it expressly accepts medical benefits.
Is the claimant's intent at all relevant when you look at the statute? If she's not entitled to benefits based on her prior release of the settlement agreement, does it matter whether she intended to release it or not? Based on the statutory construction of 440.15 sub 12.
Well, yes. It's a general release. It's a settlement agreement, and you can't. I mean, the statute, unless the agreement is somehow void as against public policy, you have to go by what's in the settlement agreement here. And the settlement agreement is absolutely clear and unambiguous. It says all claims and the only thing accepted from that in the agreement is claims for workers' compensation medical benefits.
So my question is once the JCC found that the settlement was clear and unambiguous and that the claimant was not entitled to the indemnity benefits, then the application of the statute gave the JCC no discretion to deny or grant benefits, that they simply had to require repayment to the employer.
Well, no, the JCC does have, if one of the parties, under Sanders, if one of the parties requests that, look, I think you need to inquire further into this beyond representation. I mean, if Sanders is an interesting case. It said if there are matters arise, it talks about well-represented counsel there, and so there's.
I think you misunderstand my question.
Well,
once the JCC has determined that the settlement agreement was valid and that the claimant had released her indemnity benefit, her claims to the indemnity benefits, and with regard to the recoupment by the employer, was that discretionary or not for the JCC under the statute?
Discretionary to require repayment?
Correct.
Well, ultimately, yes, it is. I would believe, because as Judge Wetherell said, he indicates that it's an equitable decision. I would not disagree with that. I mean, the JCC could say, well, look, you screwed up, and I'm not going to require repayment here. But I wouldn't say that as a matter of law that the judge was required to order repayment. I could not agree with that. So, yeah, it was a discretionary decision. I just want to finish my point, if I might, about Sanders. Sanders had talked about whether or not a claimant was well represented. I believe it just uses the term represented and then makes a reference to a claimant being well represented. That, I believe that's only in the context of whether or not there was counsel involved in creating a settlement agreement and involved in negotiations of the settlement agreement. Indeed, in some of the other cases, I believe Brewer is one of them, there was no indication that counsel was actually involved or counsel didn't sign the stipulation for a settlement agreement. That's not the case here. counsel was involved, I mean, and indeed obviously thought about workers' compensation just because of the fact that workers' compensation medical benefits is mentioned in the release. You won't find that in Brewer or Patco. Those are just general release cases. They don't mention workers' comp at all, and this court, that's sufficient to release workers' compensation benefits. I mean, here you have a general release which explicitly accepts workers' compensation medical benefits, and that clearly implies that indemnity benefits are not being accepted. I just want to make another point about or a point, the latent ambiguity. There's nothing here in this release or settlement agreement that reveals any kind of insufficiency in the contract that fails to specify the right and duties, and those are where you get into considering extrinsic evidence. It couldn't be more clear that all claims are being released except for workers' compensation indemnity benefits. There's no requirement in that section 440-2011 CB referenced, and there's no and the failure to mention indemnity benefits is simply inconsequential because of the fact that they are, impliedly referenced by dint of workers' compensation medical benefits being accepted.
Return to issue 1, if you would. Assuming the court were to find preservation on the argument that the settlement agreement was never submitted to JCC for approval of fees, in the context where the attorney is neither seeking nor claims attorney's fees, either because it's pro bono representation or because the attorney is seeking no fees for the workers' comp claims, in that case, is the attorney required to submit the settlement agreement to a JCC?
Well, it's a hypothetical question, but I would answer that it depends, because in certain situations, yes. I mean, if there's no workers' comp claim pending, is there a requirement that we go to that the EC and the employer and the claimant go before the JCC? In this case, I would say no, because there's no indication that there's a fee specifically being taken for release of the workers' comp. You can't tell.
Well, I think that's and it wouldn't be common for an attorney to say, well, this portion of the fee is for the workers' comp case, this portion of the fee is for the antitrust case or the employment discrimination case. And here, there's no segregation of the fee. So again, assuming preservation of error here, since the attorney obtained a $17,000 fee, clearly knew of the workers' compensation claims, released some and settled some, why shouldn't the attorney be required to submit the settlement agreement with the fee approval to the JCC?
Well, in the JCC, as I've indicated in the answer brief, I think that opens the door to the JCC exceeding its jurisdiction, inquiring into what happened during the settlement negotiations of what was clearly, it was an employment discrimination claim being brought here, and the JCC is going to inquire into the horse trading that went on. I mean, to what extent was, medical benefits and indemnity benefits were separated out here. So there was some horse trading going on here. Why wasn't all workers' comp? Why weren't all workers' comp benefits released?
So your suggestion to us by that comment is that it sounds like that there was a small portion, sounds like a very, very small portion, or at least a disproportionate to the $58,000 in temporary benefits that she continued to get and now is being required to recoup, that somehow that $58,000 is part of that $45,000 settlement agreement? So why isn't her argument that it, to the extent indemnity benefits are included in that $45,000, they are obviously woefully inadequate for the indemnity benefits that we know she got?
Well, frankly, to a large extent, I'm engaging in baseless surmise because we just don't know. No inquiry was made below. But in a situation where you have, and this is I won't call it a unique situation, but there was a much, at least to the employer, much more important. There was an employment discrimination claim, which can result in, not just a large damage award, but a large attorney's fees award. So the employer it's a slippery slope, because you get into inquiry where the JCC is going to be inquiring where it probably shouldn't inquire.
But I guess, as I understand, the importance of the JCC's involvement is to make sure the employee, I guess maybe more so in an unrepresented case than a represented case, make sure the employee is not taken care of, that's not the right words, but isn't making a very, very bad deal. And it sounds like if what you're telling us is that, you necessarily have to be telling us on your argument that she settled at least a $58,000 workers' compensation case, indemnity case, at least that, because there may be some permanent that it may never get to, for some small component of $45,000, then a JCC would properly be exercising her jurisdiction, at least in an unrepresented case, in evaluating whether that was a good deal or not, right?
Well, certainly. I mean, under Sanders, the parties, a claimant can request approval. If we're talking about just the required approval of attorney's fees here, again, in the employment discrimination, I mean, that was an average deal, I would submit, in an employment discrimination context. Those are the
for just the employment discrimination component.
Correct.
But doesn't this provide the potential for abuse? I mean, certainly there will be many occasions where employment discrimination claims arise simultaneously with workers' compensation claims, and that's not an unusual event. So to the extent that you have a significant workers' compensation claim, and the claimant's attorney simply wants to allege maybe a fairly weak employment discrimination claim, but then settle the case, does the workers' compensation attorney then evade the whole statutory structure for fee approval under the workers' comp law simply by characterizing the case and claims as predominantly employment discrimination claims?
Well, again, Judge Rowe, that's not the case here. We don't know how this broke down. But I imagine there could be the potential for abuse. But the key inquiry here is, I mean, under 11C, there just has to be fee approval and a determination that the requirements are that there's a fee approval and a determination of representation by counsel. Once that is made, unless the claimant seeks or one of the parties says, no, we want to get the rest of this looked into. Or, as Sanders says, if there are matters that arise after the settlement agreement, then sure, then you can look into that. But that wasn't the case here. There was a clear and unambiguous release, and that was the bargain. And to whatever extent any horse trading went on, that's not up to, I would submit, the JCC to inquire into, because it would exceed its jurisdiction to a large extent, particularly if it could strike down portions of the agreement. Because if you say, okay, wait a minute, we're going to sever out the release, the exception of the workers' compensation, we're going to let her recoup all benefits. That was part of the employer's bargain. We don't know the extent to which what kind of value the employer placed on that consideration. And as I mentioned in the brief, perhaps the employer thought that the employment discrimination claim was absolutely worthless. But wait, we think it's worthless. But I tell you what, if you release us from all workers' compensation claims, then we'll pay this amount of money. Is the JCC required to look into that? Not required? Can it? I think that would be, the JCC would be going a little far afield in that case.
Mr. Wyman, your time has expired.
Thank you, Your Honors, and I would ask that the Court to affirm the JCC's order.
Mr. Cuesta.
Thank you. On latent ambiguity, I would just like to reference you to page 28 in my brief. A latent ambiguity exists when the language of the contract is clear and intelligible and suggests a single meaning, but some extrinsic fact or extraneous evidence creates a need for interpretation or a choice between two possible meanings. Mr. Wyman has says that it's when the party's rights and responsibilities aren't clear. Here, the contract doesn't say anything about permanent total disability. The party's rights are not clear about that. There's the ambiguity that allows you to consider all the other evidence, which includes the course of dealing, 2 years of payment of temporary benefits under a settlement that purportedly settled that. On the first issue, I want to say I'm standing on Marchenko, that the JCC aborted her analysis of validity under Marchenko. She never even reached the issue of whether the lack of a workers' compensation attorney was made invalid or if the attorney's fees made it invalid. She never even reached it, so you need to send it back.
Ms. LaQuesto, if I understand correctly, your client was receiving temporary partial disability benefits at the time this agreement was reached?
You know, I think it's temporary. I really don't know, temporary total, temporary partial, I don't.
Are those essentially entitled to compensate for lost wages?
They are a form of wage loss, and that's an argument that Mr. Wyman made in his
Well, the reason I ask you is because if in fact CVS was trying to sever all employment ties with your client, why would it not make perfect sense for them to include in the general release indemnity benefits?
I think that's a friendly question, and I'm going to say...
I don't think so.
No? Well, and that's my point, is if they felt that they were going to sever...
I said to include in the general release rather than to exclude, as they did medical benefits.
Well, and that's my, they did a whole laundry list of enlisted a lot of things.
It included wages.
But they did not include indemnity or compensation, which are the terms of workers' compensation.
Okay. Thank you. Thank
We
you
ask
both.
you to reverse and remand.
That concludes our calendar for this morning. We'll be in recess.